We're talking today on the topic that says one thing you should never do with a temporary visa in Canada. The first thing is, don't let your legal status expire while you are in Canada. If you come in with a temporary visa, it might be a visitor's visa, it might be student visa, ensure that you maintain your legal status all the time. But there are circumstances, even if you come in as a tourist or a visitor's visa holder, and you come to visit either a family member or you come to visit for any other purposes, such as conferences or religious event or an award, depending on what you come for. What you just need to know is that ensure your legal status remain valid while you are in Canada. But there might be circumstances beyond your control, or your circumstances change willingly. And if you wish to stay longer than the specific time that was assigned to your visa, because you first need to understand that visa is not a right, it's just a privilege. Even at the point of entry, at the border entry to Canada, you might have a valid visa, but you could be turned back to your country of origin or your place of habitual residence, depending on your personal history or your birth history. So basically, visa is a privilege to knock at the door of Canada. However, after getting to the point of entry, it might be you coming in by road, you coming in by flight, or you even coming by sea. Some people come into Canada by sea, so it might be exceptional cases, but it do happen, and they have all the arrangement in place. So if you coming in, make sure that you have adequate knowledge about the information you provided before you obtain the visa. And if they assisted you to obtain the visa, there is nothing wrong in that. It's just that you have to be briefed and well informed about the information that was submitted on your behalf, so that if they ask you questions at the point of entry, because it's one thing to have a visa officer at the visa post that provided you with the opportunity of giving you visa to Canada. But at the point of entry, whichever entry you choose to come in from, you have Border Control Services officer. It's not nomenclature, it's not semantic. They are different from immigration officer. Prior to 2003, I believe, they were under immigration. So they have immigration processing unit, visa unit, and then the permanent residency unit, and the enforcement. But after the September 11, because of the terrorist tension at that time, which is similar to what is happening in the United States now, there was cooperation between Canada and US, so they have to take border control services serious. So as a result of that, in 2003, I believe, they created a separate agency, which in an enforcement aspect. So their focus, their mandate, their funding is different from immigration. Their own is just to detect who is not allowed to be in Canada, who is not allowed to enter Canada, who is staying illegally, who is a criminal in Canada that has no status or that has lost status, or that is inadmissible for one reason or the other to ensure that they leave Canada. So it's one thing for the one inside to be deported to leave Canada. The other aspect of the enforcement is that prevention. Before you even enter Canada, they will try to interrogate you or interview you depending on the semantic, and then ensure that you are the true owner of the visa and you have a clear purpose of coming to Canada. They are not against you coming to Canada, but they want to ensure that whoever is coming in must and should observe the objective of the Immigration and Refugee Protection Act. It's always the rule of engagement between a non-permanent resident and immigration officials, either at the point of entry, either at the point of visa post outside. They still consider visa post outside as entity of Canada. So it doesn't matter that it's located either in Nigeria, in Ghana, in the Philippines, or in United States. They still consider every embassy as extension of Canada. So whatever happened there has to be consistent with what will happen at the entrance of Canada and what will happen inside Canada. So based on that, you have to make sure you are knowledgeable about what you provided in your visa application so that you are not being turned down. It's not that they gave you what do you call it, wrong visa or fake visa, like people say, oh, they deported him at the point of entry, the agents didn't do the right thing. No, that's not true in most cases. In most cases, it's ignorance and lukewarm attitude. There's nothing wrong even if you are not sure that what was presented in your immigration application. You can get, like I always advise, always get a copy. There is nothing secret when I'm doing application for a client to now say I keep everything in secret. No, even the portal, I give you the password so that you have access to it anytime. And if you choose to change your representative, you are at liberty. It's when you have not something to hide or you are not competent enough that you'll be free. You'll be reserved that a client can change their decision and give the application to another person. There is nothing wrong with that. If you tell me in the course of assisting you, you want to change, I'll gladly give you your file to change. I have nothing to lose. I have nothing to gain. So once I do the right thing, I don't need to worry to convince you to stay with me or to take it to another person. It's your choice. But by and large, I always give access to information. I always give you copy of everything that was submitted on your behalf. So you have to know that, especially when you come in with a temporary visa. It's always the problem when you have people deported because of ignorance. So by and large, when you get to the entrance of Canada, they will interview you just to be sure you are the one that have that visa, because there are situations that what you don't know, you don't assume. There are situations that some people got visa and their circumstances change. Maybe they apply for various visa to various countries, and one comes, the other one comes immediately before they leave, and they decide to give that to another person to use it. But because you are not aware, you are not in the practice, you won't know. So because of that, the officer want to be to ensure that you are the one that is coming to Canada. You are the one the officer saw at the visa post, and you are the one that is showing up at the point of entry. Most especially since they've introduced biometric. So it has to capture your eye, and your eye has to be determined it is you. So that's one of the reasons. So by and large, if you come in eventually, you pass all the entry interview, no problem, and you are here. Maybe you came for 1 week, you came for 2 weeks, 1 month, 3 months. It depends on your visa application, especially people with multiple visa. But if your circumstances change and you want to turn it into either extension of status, which means that you want to stay longer than what you told them, how long you told them you want to stay, or you want to turn into a permanent residency, that you love Canada when you enter, you don't have intention to stay when you applied for the visa, but you now see what you don't know before. There is nothing wrong in that. They just want you to be honest and then make sure you get a concrete advice, first class information. Don't just read what is on the website. Even immigration, Canada put it a disclaimer there that is just for general purpose. It's not a law, and it's not the application of law to your peculiar circumstances, because information is always available. But what is not available is the application to your situation to achieve your goal. That's where people always have problem, and they always pay for the price that they try to outsmart. You pay ×2, or in most cases it doesn't even work because you are trying to be smart. So the first advice is consult an immigration expert for an opinion to avoid mistakes. Don't do it cheap. You yourself know that that was not the intention when you are coming. And many people always, especially we Africans, we always want to circumvent law. They will always ask why. When you say, sit down there, don't talk, there is no way. If you put 20 people and say, sit down here, one person will always say, why? And then, don't stand up. Somebody will always stand up. And immigration knows that you won't listen. So they have consequence, which is why their system work. In most African countries, the problem is no consequence, or easily you can always beg your way, apologize to avoid consequence. But in Canada, especially immigration, the consequence must stand so that you learn your lesson. For example, the 5 years ban for misrepresentation, I believe prior to 2012, 76 Act, 2002, 2001 Immigration and Refugee Protection Act, it was still 2 years. But they later saw that people are not taking it serious. Within 2 years, within a short period of time, 2 years has passed, and then the consequence is not really enforceable. There was no really negative impact. Then they changed it in 2012 under the Balanced Immigration Act to 5 years so that you can pay attention. So they always want you to follow the law. You can always do anything with Immigration Canada if you are honest and you seek legal opinion that understand the law. There is nothing that says your circumstances cannot change. You just have to do it the right way and the predictable way, so that it can be consistent today, tomorrow, in 50 years, if nothing changed. So, first advice is consult immigration expert for opinion. This is my situation. This is what I came with. I want to change to this. Is it possible or not? If it's possible, they will tell you. If it's not possible, they will tell you. But they will always tell you what is possible. And it's always possible, but it might take a modification in order for you to achieve that. So you need to understand that. Furthermore, after you've consulted, you have a plan. As soon as you arrive and you see that your circumstances has changed and you want to stay, the first thing you should do is to apply for extension of your visa. You want more time. Even if they give you 6 months, make sure you apply for extension with your reasons and pay the necessary fee. At least submit 30 days before the expiration day, because it depends on the time you apply. There might be time that you have student vacation, student holiday, that most of the student study visa holders, student, maybe they're applying for work permit, they're applying to work during the holiday, or there are people who are renewing their status, or people are coming during summer. Make sure you give 30 days, because there might be volume when that application is being submitted, and they will not run beyond the normal time, and they don't have much manpower. So it's better you give enough space when you're applying for extension of status. It's not that your status has expired. It's just that you are trying to look at your options. You are trying to strategize. So the first thing is extend your visa, whatever happened. Even if they give you extension and you decide not to stay and you return, there is nothing wrong in that. But the first thing is, don't leave it to the last minute. However, if lack of knowledge, ignorance, or due to exceptional circumstances in your case, if your status expire before you realize that you intend to stay, it's still possible. All you just need to do is to apply within 90 days since the visa has expired. Make sure it's not past 90 days, and it's common sense. If you are serious, you can't leave it for 90 days without regularizing your status. So you apply for restoration of status. That's different from when you have the status, you apply before 30 days, you are still in status. There is nothing exceptional about that. You just need to justify why do you think you still want to, you want extension of time. So that's that. The other one is, you need to notice that once you've applied for either extension of status within 30 days, even if your visa expire before decision is made, it's called a maintained status. It's still a legal status in Canada. You've applied before 30 days, but 30 days has passed, you've not got a reply from immigration. There is nothing wrong. You don't need to worry. Just stay and wait for the decision. It can come in 60 days. It can come in 45 days. But within the time after the expiration of your status and the time the decision will come, is called maintained status. You are still in legal status, even though on your passport the time has expired. No, there is nothing wrong. Once you have the evidence of submission and the time it was submitted, and it was submitted properly, so you still have what they call a maintained status. Even if you are on work permit, you continue to work. There is nothing wrong in that. If your work permit expire, continue to work until the decision comes, in as much as you've applied at the right time and on time before your status expire, and you have the proof of that. And many people don't know that, because some of the employer don't know anything about immigration. They just look at the date that your work permit expire, but they are not aware that once you've applied on time before the expiration of the work permit, or before the expiration of the visa or temporary permit, depending on your situation, you are still in status legally in Canada. You can still do whatever you were doing before the expiration of your status. Furthermore, if the visa expired and you did not do anything within that 90 days, if it's after 90 days you now make up your decision to take action, well, there's nothing wrong there. You just need not to apply for extension of status ordinarily now, because it's now in the dicey situation. So all you just need to do is you apply for special permission for temporary permit, or you ask for humanitarian and compassionate ground. So you need to note that there is one before the 30 days before your visa expire, you are in legal standing. You can do whatever you like. You just need to justify why you say you want to stay further than when you anticipated at the time of getting the visa. But if it's the second one, like we said, within 90 days, it has expired, you've not taken action, you've not made up your mind, you can still apply for restoration of status. You want to restore your status back to when it was valid. However, if it passed 90 days, that's the one we're saying now, that everything has expired, like you want to revive it, it's dead. So in that sense, you have to apply for special permission for temporary permit. You are no more asking for visitor's visa. You are asking for temporary permit, or you are applying under the special circumstances, which is humanitarian and compassionate ground, which means that under section 25, the minister gave the permission that if you ask, they should waive all the law in a layman language. I don't want to quote the law. In a layman language and simple to understand for anybody, is that you are asking for Canada to waive all the legal proceeding and then consider your circumstances. But you still need to justify why, how, and why you're asking in an exceptional circumstances. For example, the Iran and US war now. Maybe because of that now, there is no flights to go back to Iran, and you are not even from Iran. You are from any country, and there is no flight. There is cancellation of flight here and there, and then there is problem in your own country, maybe due to the oil or the policy or anything change. You can use that as a special circumstances which is beyond your control, and you want to extend your stay to be here while you are waiting for what to do next. But in most cases, you have to justify financial sufficiency so that the officer will know that you are not going to rely on the system, which is always the mindset of a decision maker in immigration. They want to be sure you are not going to be a dependent on the system. So maybe you are going to move money from your home country, or you have people here to support you. You have to justify that in your request. Then the other one will be, after we've talked about how to, if it's possible, what to do to maintain your status, because you're still maintaining status as a temporary resident. However, because human nature is dynamic, you now change your mind. I want to convert that visitor's visa to permanent resident. I want to stay in Canada. The question will now be, is it possible? Yeah, it's attainable. I won't say possible, but I will be semantic about it. It's attainable, but it's very complex and it's unusual, because from the point of visa post, you told them they are coming here for a temporary resident. Although it's not against the law, because even the Immigration and Refugee Protection Act provided make provision for such circumstances, because they know human being is dynamic. Your circumstances can change, your situation can change. So therefore, if you look at the Immigration and Refugee Protection Act, under section 22 subsection 2, yeah, you have dual intention there. But the dual intention there was provided by the Parliament not to be abused, but it has to be justified. It has to be in a special circumstances that deserve that. For example, in Canada, that's what the Act says. In Canada, although dual intention is not contradictory, okay, Immigration Authority, that's IRCC, view temporary and permanent intent as complementary, not contradictory, as long as the applicant remain truthful. That's the condition. They know your circumstances can change. You are a human being. Things can change. You can change your mind, but they just want you to be truthful. Does it change? Or are you aware you know it's going to change and you are not being truthful? Or your situation really changed when you get to Canada? You see what you don't see at the time of coming and you want to take advantage of it. And there is nothing wrong with that, because one of the objectives of immigration is to create economic benefit to Canada. So if your situation changes and it's going to be economically viable or beneficial to Canada, there is nothing wrong. That's why immigration officers are there, to ensure that they promote economic benefit to Canada. But you have to be truthful. It's not just being circumventing the law. That's what they don't want. So it is attainable but unusual and complex, like I said, particularly from a temporary resident visa, that is TRV, to a work permit without leaving Canada. You came in as a visitor, now you want to become a worker. Yeah, it's possible if you see a job offer, but it's complex and it's unusual. So it's allowed, especially during COVID. Yes, many people were trapped in Canada. That's what prompted the dual intention that was properly used at that time. It's beyond your control. Many of the visitors in Canada were trapped because of the COVID. There is restriction in movement around the world. So in that, at that time, many people were granted work permit within Canada without stepping out, because it's an obvious reason. There is nothing much to justify. It's common sense and the officer are aware of what's going on around the world. But that ended in 2024, I believe. Yeah. And since then, they've not reinstated such program. Because a visitor, like I said, or a tourist came to Canada for a temporary visit. So what changed? You have to justify. It's not that something cannot change, but just give us reason. Then they would be able to change it for you to meet your desire. Going further, there are step-by-step guides on how to change your visa status. You are in Canada as a temporary resident, which is a visa, but you want to change it now to either to a work permit or to a temporary or a permanent resident. So a visitor can apply for a change of status from visitors to work permit, provided he or she have invitation from employer. You have to have a job offer. If you have a particular skill and you are in Canada and you visited some companies that are related to your skill area, yeah, you talk to them. There's nothing wrong talking to them, and they gave you a job offer, which they said they want to employ you. There's nothing wrong in that. All you just need to do is that you just need to get a labor market impact assessment from the Human Resources and Skill Development Canada. Why are they doing this? They are doing this because the employer has to justify. You see the word they use there, labor market impact assessment. Giving you job offer as a visitor, letting you come in as a visitor and work in Canada, will it impact Canadian citizen or permanent resident? Will they many people lose their job or the chances they're supposed to have because visitors are coming in to take up their job? So they just need to satisfy the Human Resources and Skill Development Canada. They will ask some question to the employer. Have you tried many Canadians? Have you tried permanent resident? So that you could not get anyone, then that's why you are being given this exceptional situation. For example, now, because of the change and enforcement law in the US now, you have a lot of construction workers that are being sought out for, but they could not get. So if things change in US now and you apply under the construction worker category, they will definitely give you, because many US citizens are not willing to do such job, or the farming job, to pick fruit from the farm. They are not willing to do it. Most people from Mexico and Caribbean come in illegally and do such job. So if you do that under the skilled, under the labor market assessment to human resources and skill development, they will grant the application. However, it's not permissible to work in Canada. Is not permissible to without a job offer and social insurance number. So you need to get a social insurance number so that whatever work you do, whatever tax you need to pay will be remitted based on your social insurance number, because your employer is supposed to get your social insurance number as you are working. They will take in taxes and then remit it to necessary agency, which is CRA, Canada Revenue Agencies. So based on that, it's still the same human resources, which is labor, human resource and skill development, that will issue you what do you call it, insurance, social insurance number. So they are the one to make that determination. First, they are protecting Canadian jobs. Secondly, they are trying to, if eventually you get a job offer as a foreign national and you work, you need to pay tax. So they want to make sure they obtain the necessary tax or derive it from your income. So that's why they put all those measures in place. But in some cases, if you apply, even if you get a job offer, that's why I say you must continue to maintain your status. If the result or the decision did not come before your status expire, you must leave Canada. But it doesn't mean because you left Canada that job offer application has ended. Once it's approved, you give them the necessary contact information, either email that is accessible while you are outside Canada, or if you are using the mail address, mailing address, you use address that you know they can reach you, or if you have a contact person in Canada, you use address that the person will give you the letter once the approval letter comes. So if you leave Canada and the approval letter comes for the job offer, for the work permit, then you use that to come back to Canada. All you just need to do is to contact the visa post and submit that to them. They will do all the necessary paperwork for you to return to Canada. So that's why I'm saying that once you do things truthfully and you do it with proper professional opinion, there's nothing impossible in changing every situation you may be to achieve what you want to do. But it's just lack of knowledge, ignorance, and inability to invest in quality information is one of the reasons why people get immigration wrong. Furthermore, there are other situations you might change your status, your legal status as a temporary visitor in Canada or a temporary resident in general. If you come in as a student and you are studying, if for any reason you are unable to continue to study, either based on the medical reason you want to change your circumstances, you're supposed to be in school, but if you are not in school, then you make sure you change to a visitor status, because you cannot hold the study visa and don't go to school. But you can still stay in Canada legally even if your circumstances change and you can't go to school. So all you just need to do is to ask for a change of status. From study visa, you change it to visitor's visa, and then you just need to demonstrate for the officer what is your reason, and then you have to show financial sufficiency, which I always tell you, that's more important. They want to know you won't live on the system. You'll be self-sufficient, and then they change it for you. Maybe you have a breakdown, you have a medical reason, and you change to visitor's visa while you're taking care of yourself. And if that circumstances improve and you are better off to continue your study, then you reapply again for study visa. Then they will give you study visa to continue. But most of the problem out for people is out of ignorance. They will just stay with the study visa, don't go to school, and leave it because they gave them 2 years, they gave them 4 years. They thought it's still valid. It's not valid if you don't go to school. So you have to make sure you maintain class. If you don't maintain class, then change it back to visitor status so that you are in good standing. But because they've given you 4 years, 3 years at the visa post doesn't mean it's still valid. Once you don't go to school, it's not going to be considered a status. The other one is if you see possibility, go online for provincial nominee and you believe you qualify after you come to Canada. There are programs rolling out by province, because provinces and territory have their own immigration programs, while federal immigration have their own program, and also Quebec have a separate immigration program. So there are 3 immigration programs within Canada, even though it's one country. So you have to be aware of that. So based on that, if you see opportunity that a provincial nominee program comes out and you think you qualify, you can apply, but in most cases it takes longer that your status may not allow you to stay till the process ends. So in that case, you can apply, and once your status is about to be expired, you step out of Canada and you continue. Once that is granted, you use it to return to Canada. But the problem is, if you now overstay and don't say anything, even though that provincial nominee is going on, it's online, it doesn't matter. At the time the federal immigration will be asking for some things, the status issue will come up. So it's better you don't abuse it. That's why I said consult an expert if your circumstances change and you want to take advantage of the situation. So there is nothing wrong from visitor's visa to turn into permanent resident. We just have to do it properly and be truthful about it. Another step you can use to change visitor's visa or temporary visa to permanent one is through the family class. You came in through immigration to visit or as a tourist and return, but maybe when you came to Canada and you went for an event, you met somebody and you started a relationship and it became serious. So if that be the case and the person is a permanent resident of Canada or the person is a Canadian citizen and he or she chooses to sponsor you to get your paper so that you can stay together in Canada, there is nothing wrong in that. But the only condition is that that relationship has to be genuine and it should not be entered into for the purpose of getting immigration advantage or immigration benefit. It's not an arranged marriage. It's not a marriage of convenience. It's not a marriage that it's in bad faith according to section 4 of the immigration regulation. So bad faith is always the problem with marriage under immigration. So Once all that has been satisfied, there is nothing wrong for you to get married and get your legal status. And the recent changes make it more convenient. While you are waiting in Canada, you will be eligible to apply for open work permit, which means that you can work while the application is being processed, and you don't need to return to your home country. The other one that is usually being abused and misused is through the asylum claim. That was especially for Nigerians. If you remember, was it 2007? No, 2017, 2018, I believe. The minister was compelled to even visit Nigeria. The immigration minister was compelled to visit Nigeria and to the visa office in Nigeria. And also I recall in 2000, and I think it's 2018, yeah, I was in Nigeria too. I have meeting with visa officer, and we discussed, and I think she was in Abuja and she came to Lagos. We have discussion, and she was telling me that your people are so funny that there is nothing they cannot provide to guarantee you, and they will still go back with the benefit of doubt to Canada and make a refugee claim. She make reference to people who have 5 years UK multiple visa and probably 2 years or more US visa, and they will still come back, come to Canada, that they are going for a visit, and they will soon come back, and they will eventually make refugee claim in Canada, which is was unbelievable at that time, because many of these people are professionals. They are either in banks, oil company. I don't know what happened that particular year, 2017, 18, 19. Yes, there was a lot of crazy decision that people are just making massive refugee claim, and many of them fail because, like I said, there is dual intention. But if you're making refugee claim, one of the conditions is that your reason must be that you are afraid of fear or danger, and that danger technically must be well founded. That risk you are afraid of must be well founded. It must be risk to life that is well founded. And the mistake many make is that not all risk constitute persecution. So under the refugee process, you are afraid of persecution. You are not just afraid of risk. The risk has to be persecution or cruel and unusual treatment under the Convention Against Torture. And the refugee process must be under the Refugee Convention of 1951. So many people are not aware because they get advice, bad advice from friends or read online and say once you say your life is in danger, then you would be accepted. No. The acceptance is misconstrued. You will be accepted to make a claim, but will that claim be successful? That's another issue. So you have to be sure that your case is genuine, your risk is well founded, and your risk is cruel and unusual, and it fitting within the regulation and the immigration, because they have specific immigration section. Under section 96, you have to be a conventional refugee, meaning that your life must be in danger under 5 itemized category. Maybe for your political opinion, you are criticizing the government, then you could or you should be accepted as a convention refugee. Maybe for religious persecution, you can be for religious persecution, which is understandable. Okay, then your nationality can make you a refugee because it's been defined since 1951 that whoever is seeking asylum in another country based on nationality, which is one of the condition of the section 96. For example, to understand that, you use people like the Palestinian or the Jewish. There are some Jewish that has element of Palestine, and there are some Palestine have Jewish element. So depending on the circumstances, you can be persecuted because of your nationality. Also, if you go to Iraq, there are Kurdish Iraqi that are originally from Turkey, but they are in Iraq or they were born there. So you can be persecuted based on your nationality. Furthermore, in case of Nigeria, in the late 60 towards 70, there was civil war. Some people saw or refer to themselves or believe they are Biafran. They are not Nigerian, and they were being persecuted because of the war. So, which brings issue of nationality into it, how individuals perceive themselves. So you can be persecuted because of your nationality. That's the third one. The fourth one is we talk about based on the other one is membership in a particular social group. You can be a membership in a particular social group and you are being persecuted because you belong to a particular social group. For example, that particular social group was the last ground in 1951 when that legal instrument to determine who to protect, who not to protect in 1951 after the Second World War. I believe the meeting took place in San Francisco in California, United States. So they foresaw that in 1951, because human endeavor is dynamic, they are not sure what changes will come in 10 years, in 20 years, in 50 years. So they now left it as a open-ended category that you yourself that is seeking for protection must justify that. So that's why they left that. So for example, there was no homosexuality. It was not, there was, but it was not popular at that time. So now you can use homosexuality as a constitution ground for membership in a particular social group. And also you can use any other one, especially women now that are said they are being abused by their husband. They want to either kill them or abuse them, continue to be abused. Yeah, they can use membership in a particular social group, but they just have to annex another instrument that is chairman's guideline on gender-based persecution. So when you get to all that, if your circumstances warrant that, your legal counsel will advise you further. So those are the ground that you can use for asylum, but it's being misused and many people have been misled. When everything failed, they just jump to the asylum. But what they don't know is that the day you make asylum, they will issue a deportation order for you immediately, and they will fingerprint you. So meaning that it's not that they will deport you right away, but they will make sure you pass through the process, go through the Immigration and Refugee Board to make a determination. If everything fails, you will be deported to Canada. So that's why that one is very risky. You have to ensure that you are not being misled. It's better you consult before you make a refugee claim, which is a temporary visa application. And in most cases, what will be the legal obstacle in most of the cases I've reviewed, is that when you are getting that visa, you did not say something happened, or something is after your life. You're even saying that you're going to return quickly. So what works for you to get a temporary visa, in most cases will work against you to get a permanent resident in Canada, because they will now ask you, when did the problem started? Is it before or is it after you get to Canada? And there is what they call sous-refugee. It's a French term. You can, if your circumstances fall within sous-refugee, yes, you can get asylum from temporary resident to an asylum to become a conventional refugee or person in need of protection, because your circumstances change, not before you left your country, but it changed after you arrive in Canada. It's a French word. It falls under sous-refugee. If you're doing refugee claim, then the judge will know that this is a real refugee claim, is not a bogus refugee claim. So you need to seek expert opinion before you make that decision. There are a lot of people that made, especially the Nigerians in 2018, 2019. Many of them have been deported, or many of them are underground now, and people think they are in Canada. They are in Canada without status. So they've exhausted all the legal loopholes, because the circumstances change when. That's the main problem they are unable to surmount. So you need to make sure you seek proper opinion before you take that risky decision. The other one is that you can apply under humanitarian and compassionate ground, but like I said, you have to justify what constitutes humanitarian and compassionate ground. You are telling Canada to throw away the law and consider you. So you have to use a legal, persuasive argument with the necessary authority. And you have to make sure you draw your authority from the relevant instrument that the officer will be comfortable to side with you and make a positive decision. For example, you have to, the rule of engagement is you have to either cite the Immigration and Refugee Protection Act. Then you have to, there are other associated regulations which you have to bring your argument within that for the officer to throw away the law of Canada and consider your application. Furthermore, there are federal court cases and decisions which are precedent that you can use that fit in your circumstances to justify why you qualify for humanitarian and compassionate ground. And you can also use operational manual for that. Operational manual is usually what the officer uses as a guideline to make decision. If you're able to access it, which is available, but you just need to understand and articulate it, that this operational manual allow you to do this and do that for me, and then they will be persuaded to grant your exceptional circumstances. And that circumstances in most cases are situations you can't control. It might be legal, it might be medical, it might be war, changing circumstances in your country. You came in, you can't return. Maybe you are a member of the government at the time you are leaving, and then the government has changed before you are able to return. So there are exceptional circumstances, but it has to be genuine and truthful, like we talk about in the first instance. And the last one is that there are pilot programs under the public policy. Mostly they are ministerial instruction that the minister always give instruction that maybe circumstances has changed. For example, the war in Iran and US, Israel now, there will likely be a change in Immigration Act that address such issue. And usually they call it the ministerial instruction. The minister is going to issue an instruction under the public policy and say we are addressing this issue, and this kind of people or category of these people might want to ask for this or ask for that, and they will grant it. That happens in is it 3 years now or 4 years going for the Ukraine war. Many of the Ukrainians that came in before they were able to return, there was invasion of Russia. So that bring another public policy, which is from the minister, and they were accommodated under such program. And Haiti too has problem with their government in Haiti, and there were circumstances that brought ministerial instruction, and there are earthquake in Haiti that also brought such situation. The other one was what's this country in Africa? Sudan. There was militia war here and there that affected many Sudanese that were in Canada at that time. So they can't return to their country. So you need to understand all this, but if you are not sure, it's better that you consult an expert on immigration before you take any decision, because immigration is very costly if you don't take preventive measure. But if you take preventive measure, you avoid enforcement. They're spending more on enforcement now because they are taking security serious everywhere in the world now. I recently read about the deal in Nigeria with UK now, and I will talk about that next week, about the migration deal signed between Nigeria and UK, to enlighten people more about that. It's a good deal depending on the part you are, because people are going to leave home now with dignity rather than just being suddenly deported. I'll talk more about that next week. Thank you for your time. Bye.